On September 22, 2022, Cleveland Heights Police Department officer Carly Lewis
Rio, stand by. Send me another unit because another...
nearly causing a 3-car crash. Mr. Kern pulled over behind Officer Lewis and the other vehicle she stopped to talk about her driving.
Causing me to stop abruptly. Causing you to stop. Yes.
He gets a ticket for there's no ifs, ands, or buts about this.
And doesn't know how to surrender to licensed sirens. Don't you see him off the road?
Okay, I did not do that, sir. The lights and sirens on my marked patrol because he stopped abruptly.
Where's your music? Dancer, I had lights and sirens.
Sirens on, sir. I apologize. He stopped abruptly.
However, sirens and lights were on. I started sirens and lights.
If it's something wrong and you actually did it, all you say, my bad.
And I did.
Just keep going. My bad. I initiated a traffic stop in a marked vehicle with lights and sirens. If you didn't hear sirens or see light, you backed up for safety at a traffic halt.
I initiated a traffic stop in a marked vehicle with lights and sirens. If you didn't hear the sirens...
Under revised code section 4511.45, no driver of any other vehicle shall fail to yield the right-of-way immediately, drive, if practical, to a position parallel to and as close as possible to the right edge or curb of the highway, clear of any intersection, and stop and remain in that position until the public safety vehicle or coroner's vehicle has passed. Although there is no footage of the traffic stop, Officer Lewis and Mr. Kern's accounts suggest that Officer Lewis initiated a traffic stop with the driver in front of Mr. Kern before changing lanes and pulling over the other car. When Officer Lewis initiated the stop, the other motorist stopped sharply, nearly colliding with the 3 vehicles.
However, the lights and sirens were on. I initiated lights and sirens.
Without camera footage, it is impossible to verify whether Mr. Kern violated section 4511.45. But even if Officer Lewis had her siren activated, he likely did not have enough time to yield owing to the narrowly missed accident. If a court found that Officer Lewis was sounding a siren and Mr. Kern had time to yield but did not, it would likely find probable cause to hold him. Also, section 4511.45 notes that this section does not relieve the driver of a public safety vehicle from the duty to drive with due regard for the safety of all persons and property upon the highway. Even with her lights and sirens on, a court may find Officer Lewis drove recklessly due to her risky manner of initiating the traffic stop. Mr. Kern added, "I'll report it, but I need your ID. Talk to me. You and I understand. We just saw what happened to him. Okay, I asked for help because a man is walking towards me from a car."
You know how society is. I know how society is. Now listen.
Right.
I'm asking...
I need your ID to tell my dispatcher who I'm with. Not identifying as obstacle. I commit you as a secondary. No crime, but I'm identifying you.
Identify yourself so I can let my dispatcher know who I'm out with. If you don't identify yourself, that is obstruction.
As previously mentioned on ATA, many states, including Ohio, have stop and identify laws that require people to identify themselves during Terry stops. The Ohio Revised Code states that no person who is in a public place shall refuse to disclose the person's name, address, or date of birth when requested by a law enforcement officer who reasonably suspects the person is committing, has committed, or is about to commit a criminal offense. Section 4507.35 of the Ohio Revised Code requires drivers to show their license to peace officers. When appropriately demanded, the operator must present the driver's license on or around their person. In 2017, the U.S. District Court in the Northern District of Ohio explained in Johnson v. Hasu that an officer can seek a driver's license under this provision if they suspect a crime. While Mr. Kern had stopped and exited his vehicle, a court may find that the officers had reasonable suspicion to demand his license in compliance with this statute. Although rare, courts have upheld traffic stops without an officer stopping the car. In Thornton v. United States, 2004, the Supreme Court upheld the search of a vehicle after a traffic violation detention.
Okay,
Thank you.
I need your driver's license.
Look, man, I'm sorry.
Until after he parked in a parking lot and got out of his vehicle. Based on Thornton, the 8th Circuit Court of Appeals ruled in 2011's U.S. v. Randolph that an officer may initiate a traffic stop after the driver has stopped the car and exited the vehicle. Thus, a court may rule that the authorities could hold and demand Mr. Kern's driver's license after he was already out of his car. As with the stop and identify provision, the Constitution and Ohio law require officers to have reasonable suspicion that Mr. Kern was breaking the law before detaining and identifying him. We'll address whether the officers had probable cause to suspect Mr. Kern of obstruction later in this episode. For now, it is important to note that unless reasonable suspicion existed that he had committed a traffic violation or criminal offense, he was not required to identify himself or display his driver's license under either Ohio statute, and he was never required to provide his social security number. Mr. Kern says, "I'm not on your phone. Seat yourself."
Have a seat.
What's wrong with you, man?
Have a seat.
I'm sitting down.
All the way in.
That car matches a bizarre description from yesterday. I saw. Traffic stopped at my request. That person abruptly stopped instead of pulling over. He was extremely near to him, and that driver stopped so aggressively that we almost crashed. Okay, he got a ticket for obstructing and not identifying himself.
I didn't do anything.
Listen, just all you have to do is
I don't have my ID with me.
1921.31 of the Ohio Revised Code. No person, with purpose to prevent, obstruct, or delay the performance by a public official of any authorized act within the public's official capacity, shall do any act that hampers or impedes the public official's lawful duties. Some courts have concluded that interfering with a traffic stop is obstruction under this provision. In Douglas v. Swing, ruled by the U.S. District Court in the Southern District of Ohio in 2011,
Did you have your license siren on?
I did, yes.
He gets a ticket for there's no ifs, ands, or but about.
the home's inhabitant came alongside the cruiser, backed up, and angled his headlights towards the automobile the officer had stopped. Then he revved his engine, drove between the cruiser and the halted vehicle into a yard, and yelled at the officer. The court found that the undisputed facts make it readily apparent that the officers had adequate probable cause to arrest him for obstructing Officer Swing's traffic stop. The Swing case is different because Mr. Kern parked considerably behind the cruiser and stopped vehicle, did not disrupt Officer Lewis during the traffic stop, and waited until she came over to talk to him. When Mr. Kern stopped his car to talk to Officer Lewis about her driving, a court would likely find him not guilty of obstruction. Based on his failure to identify himself, a judge would likely find that the officers lacked probable cause to arrest Mr. Kern for obstruction. State v. Pierce's 2017 3rd District Court of Appeals stated, Ohio courts have consistently held that, in order to violate the obstructing official business statute, a defendant must engage in some affirmative or overt act. Fail to offer police required information is usually seen as omission rather than act. In Walsh v. Erie County Department of Job and Family Services, 2003, the District Court in the Northern District of Ohio stated that the obstruction statute requires that the officer must be in the performance of an authorized act, and that requirement cannot be met where the officer's act is not authorized by law.
You violated my rights. You know.
Well, we'll all be in court.
You probably don't.
A court would likely find that the cops did not act authorized if they did not have probable cause to demand that he identify himself. Officer Lewis cited Mr. Kern for obstruction of official business under Cleveland Heights Ordinance Section 525.07, which replicates the state obstruction legislation, and told him to leave. The prosecution that the charge be dropped 11 days later. Mr. Kern complained to Sergeant Wolf hours after the traffic stop. Cleveland Heights Police Chief Chris Britton ordered Sergeant Wolf to de-escalate after investigating the complaint. Additionally, Cleveland Heights following this interaction, Mayor Khalil Seren established an oversight bureau within the police department to provide executive oversight of the Division of Police and update the department's policies and procedures for receiving, investigating, resolving, and reporting complaints related to police conduct. This conversation has prompted Mr. Kern to employ an attorney and launch a GoFundMe page to cover legal bills. Since this episode was written, no lawsuit has been filed. Comment below with an interaction or legal topic you want us to discuss. Thank you for watching.